Oshimole. I represent the good people of Edo North from Edo State, where my Lord, the acting Chief Judge, did our NYC. Like everybody has said, sir, no one will look at this CV and want to ask questions. And I thought that for those who are in doubt, this training is not an act of favor or punishment. We just want to be enlightened as to have a window into the way in which the mind of the next Chief Justice of Nigeria works. So for Kalu, I needed to understand that we are not doing her any favor by saying, take a bow. In any case, that has been settled. I just want to ask one or two questions. You know, my Lord, when we complain of crowded court, the courts only adjudicate based on the judicial confined on it by Parliament. For example, when my case went to court as a governor or governorship dispute, the law then was that cases are terminated at the Court of Appeal. The National Assembly, in its wisdom, chose to remove that bar and say the cases must now terminate at the Supreme Court. So we can't overload a vehicle and then blame the driver for carrying overload. But there are a couple of issues that I believe many of us distinguished senators must be aware of. That depending on the party you belong, at the level of the state judiciaries, people tend to prefer, talking about forum shopping, to file cases before Federal High Court, particularly if it's a case in which you believe the state governor or the state government may have an interest. And how we deal with this, how the Chief Justice of the Federation can encourage judges in the states to show the same level of courage to pronounce where it's so discovered that a state government or a state interest, a state governor has crossed the red line, that people should feel able to go to a state high court and get justice. I don't want to rush to federal high court because of the fear that judges, in many cases at the state level, don't want to enter judgment that will be offensive to the state executive. That is recently in the state, and for obvious reasons, I won't mention the state. The National Judicial Council approved the appointment of new judges, which is in line with the Constitution. But the state governor in Benin decided, I didn't mention him, I mentioned a city. A state governor in Benin refused to swear in. Excuse me.
You are protected. You did not mention the state. You only mentioned Benin.
Thank you, Mr. President.
Benin is not a state.
That's right. So, as we speak, those judges were not sworn in, even though they have been cleared by the National Judicial Council. When I was a governor, sir, there was a case, a judgment against the state government. But because the governor has immunity, the judge decided to sentence, to convict the Attorney General for contempt of court. So I'm like, if a state governor disobeys a ruling of a superior court, and because the governor has immunity, there is nothing you can do, I would have expected that the Attorney General will be charged for contempt of court or showing disrespect to the National Judicial Council, so that the discretion we exercise should not be abused to the extent that all of the processes that the National Judicial Council goes through to select and approve and forward to the governor for ratification. I am sure, Mr. President, you approve many such recommendations, not necessarily because you like the persons, but in the wisdom of the National Judicial Council, they've cleared them. So I thought that there might be, like to know how whether a legislation is required or the Supreme Court, being a policy court, what it can do to help to curtail abuse of power at the level of the state. And lastly, there was this case of Mr. I don't know whether I should mention his name, a guy who was sentenced to 3 years in prison, up to the Court of Appeal. And the Supreme Court found that this was a criminal case that has to do with somebody who operated or officiated at the, I believe, MPA. He served all of the 3 years in prison. And then the Supreme Court found that he was wrongly convicted. The only benefit he's got is that he cannot now be referred to as a convict. But he suffered the punishment for 3 years. In such cases, where the lower court has misapplied the law, and a citizen has been sentenced to prison and served the whole of the 3 years, or even 5 years, is there a way in which the Supreme Court can order compensation for victims that suffer such humiliation for an act for which they were never guilty? And each time I see the guy on television, I wonder how he feels that he was in prison for 3 years, and the Supreme Court found that he was wrongly jailed, and yet he has suffered it and there are no compensation. I would have imagined that the court can award compensation, huge compensation, not the type that is not even enough to pay the cost of a senior advocate, but one that will also fairly compensate the victim for the period he spent in jail wrongly. Thank you, my Lord, and I also want to congratulate your family, because having seen that you serve in virtually all the judicial, north, south, east, west, that means that for most of the time, members of your family were alone. And so for you to accomplish this, I think members of your family deserve commendation as well. Thank you, Mr. President.
Oshimole, we have to return back to the serious business of screening and asking pertinent questions. You need to know that even outside this climb, screening of this nature sometimes takes 42 hours. In some jurisdictions, Chief Justice of Nigeria and even Justice of the Supreme Court designates are screened for up to 2 days. So, my Lord, it's not a waste of time. It is because Nigerians have a lot of questions that they want to ask, and they cannot ask those questions. We are their representatives. We are the ones that can ask. They want to hear from you as you are coming in, because after this, hardly will anybody see you, including my colleagues here. So this is the only time we can see you. So, and that's why almost everybody is struggling to ask one question or the other to hear your perspective to issues. And then we can now forecast on the judiciary in the next 5 years, commencing from the reforms we are going to bring. Distinguished Senator Ningi.
Thank you, Mr. President. My colleagues, my own is just at the point of caution of the Senate. The executive that comes to this room, when they are here, we used to ask the female counterparts to take a bow and go. Why are we doing a different thing in the floor of the Senate, where she deserves to take a bow and go? So, because when the executives are here, we ask the women to take a bow and go. Why? For a woman, no, I'm coming, please. For a person have gone to this level, she has served the country, and she has answered all the questions. And you people are still putting your hands up to continue keeping her. I mean, it does not make sense, my colleagues. I only want her to explain to me just one question. My name is no. My question is commendation. That a woman of this level has gone this far. My motion, I'm putting a motion on the floor of the Senate. I'm putting a motion on the floor of the Senate. Mr. President, I'm putting a motion on the floor of the Senate.
We will not entertain motions when we are doing this kind of important screening.
No, it's very important, but we have contradicted our rules.
I want to thank you for your contribution. I want to thank you.
We have contradicted our rules.
I want to thank you.
Our rules is that I'm moving a motion that she should take a bow and go.
Recognize me. My name is Senator Abdul Ningi, and I represent Bauchi, Central of Bauchi State. Let me join Mr. President in welcoming you and our Lordship to this very august chamber, and further congratulate you for this very, very special nomination. I recall seeing you in the confirmation of Justice Mohammed Tanko and Justice Ariola. You accompanied both of them. And one of the highlights of those two sessions was the issue that was raised by Senator Kwaka, SAN, on the issue of the ex parte order and the assurances we had then received by their Lordship doing something about it. These ex parte orders, my Lord, has become a tsunami in Nigeria, and therefore some of us begin to wonder how easy are these orders assessed. I can tell you straight that 6 years ago, Your Lordship, I had the opportunity of visiting a political friend in his office, and he opened his box and brought 5 ex parte orders in advance. Ex parte orders in advance, and from a competent court of jurisdiction in this country. And it makes me wonder how that is possible. And you could see within the last, by the time I met him, he was using these ex parte orders. All they were doing was to fill in the gap, fill in the dates. And he has assessed these ex parte orders in anticipation of possible problems by political opponents. And believe me, my Lordship, those orders succeeded at the end of the day. Now, the question that I would like to ask you, is the hand of the judiciary tight in the possibility of not meting out sanction? Or do you need an intervention of legislation in making sure that such irresponsibility is actually made by a law of the National Assembly, making sure that it's criminalized? What's your opinion about it? I know, as a fact, you made mention of the necessity of this ex parte order, but you can see clearly it doesn't work in this country. People have these orders left, right, and center. People are trying to block road of justice at every given time. And I want during your tenure, so that by the time the next justice is coming before the Senate, this question may not arise. But these two justices, they assured us something will be done, and actually nothing serious is being done about this matter. Please, I want you to comment. Thank you.
Senator Kombowe Friday Benson, representing Bayelsa Central Senatorial District. Mr. President, sometime on the 10th of May 2016, while addressing an audience, the Prime Minister of the United Kingdom made a very open declaration about Nigeria and Nigerians. that Nigerians are fantastically corrupt, distinguishing nobody, excluding nobody. The statement was so clear that Nigerians and Afghanistan, these two countries are the most corrupt countries in the whole world. And here we are. Sir, I want a very distinguished acting Chief Justice of the Federation to help us to explain those who David Cameron were actually referring to. Are they here? Which of them are the corrupt Nigerians? Are the senators corrupt? Is the judiciary corrupt? Which of them, which of the Nigerians is David Cameron referring to? Mr. President, sir, are we expecting a corruption-free moment and period of our reign in Nigeria? That is my question, sir.
Distinguished Senator Ekong Samson, Akpabio South. I will address the issue of the need for substantial justice and whether there must be compliance with the issue of substantial justice and technicalities. Over the years, we have emphasized in our judgments about the need for courts to promote substantial justice over technicalities. However, I believe that sometimes there's a misconception on what constitutes technicalities. Because we have rules, we have laws, we have precedents that we follow. And where a precedent is followed, it will not be correct to say that the court has enthroned technicality over substantial justice. All courts are admonished all the time to eschew technicalities, but it's not in every instance that matters are decided on technicalities. At the same time, where the court looks at the case before it and decides based on the facts and the application of the law. Sometimes the application of the law to the facts might appear to be rather technical. And this is why we also have the appellate courts who can correct errors where they are made. On the issue of elevation to the Supreme Court, I will crave your indulgence to leave that question for a different forum. Distinguished Senator Adams Oshimole from Edo North. You talked about the crowded courts docket and the position where at a point in time matters terminated at the Court of Appeal, later on moved to the Supreme Court, and then the difference between cases filed at the Federal High Court and cases filed at the State High Courts. What I would say is that it is the legislature that enacts the laws that confer jurisdiction on the courts. And therefore, anybody who has an option to go to either the Federal High Court or the State High Court is entitled to utilize that option. At the same time, where cases are decided, where it appears that a certain side is favored, the appellate procedure is there. And I think that is the only way we can curb it, unless there is clear evidence of bias or any inducement, corruption, or anything like that. But other than that, whatever decisions are given, the option is to go on appeal. And if you can satisfy the appellate court or the Supreme Court that the court concerned was swayed by other considerations, then the court will give whatever judgment is applicable in the circumstances. Now, on the appointment of new judges, the situation where judges have been recommended for appointment and they have not been sworn in that instance, the National Judicial Council has made its position very clear, and it is the National Judicial Council that gives the directive for who should be appointed. And once that is done, there is nothing more for the National Judicial Council to do. It is to the detriment of any state concerned if it is now working with a lower number of judges, and you have capable and already confirmed judges that are not being able to carry out their duties. It is not a matter that the Supreme Court can intervene in unless a matter is brought to the Supreme Court on that issue. The issue of compensation for a person who has served his time and found to be not guilty, can the Supreme Court order compensation? The Supreme Court can only decide on matters that are specifically brought before it and grant reliefs. And where there is no legislation that gives the court that power or that authority, there's nothing the court can do. At best, the court can just make an obiter comment on it, that this is a situation where, in ordinary course of things, this person ought to be compensated. But it's not for the Supreme Court to unilaterally make such an order, because everything we do has to be based on the jurisdiction that is conferred on the court. Distinguished Senator Abdul Ningi from Bauchi Central, you asked for assurances with regard to ex parte orders and an issue of ex parte orders prepared in advance, whether the hands of the judiciary is tied, and whether there should be legislation against the grant of ex parte orders. Now, the situation with ex parte orders, where it is, you see, in order to have the judiciary that we desire, we also need to be able to follow through on certain issues. If there's a situation where a judge is found to have ex parte orders prepared in advance, such a judge should be reported to the NJC and necessary action will be taken. It is not fair, even on the judiciary, when these allegations are made and nothing is done to substantiate them or to follow up on them. And we know that even when petitions are filed before the NJC, in some instances, you find that the petitioner comes back and withdraws the petition. So it is important for the NJC to be able to exercise its own powers, that these sort of matters are brought to its attention. And then the grant of ex parte order is discretionary, but there are guidelines. So where a judge is found to have ignored those guidelines, to have acted without due regard to proper process, or even the facts of the matter, then the necessary action will be taken once it is brought to the attention of the National Judicial Council. As I've mentioned, the code of conduct will be strictly enforced, and judges are admonished not to grant ex parte orders indiscriminately. So it's an act of misconduct. But at the same time, it would not be proper, in my humble opinion, to enact a law that does away entirely with ex parte orders, because they are necessary in certain circumstances. Distinguished Senator Ofowe from Bayelsa Central. Pardon? I beg your pardon. Oh, I want to believe that his question was rhetorical, and I have, I think, the permission of His Excellency to pass it over about whether who are those corrupt people. Then, Your Excellency, your question: should judicial officers allow social media to influence their decisions? Certainly not. We have taken an oath of office to carry out our responsibilities without fear of favor, affection, or ill will. So whatever is in social media definitely should not affect the way we make our decisions. However, it is true that there is a lot that goes on social media and other fora. And this is one of the aspects that contributes to the negative perception of the judiciary, because you have narratives out there that have no correlation to the facts that are before a particular court. And again, whether they are senior members of the bar or other members of the bar, there are procedures. A senior member of the bar who has earned the rank of silk, it's a privilege. It's not a right. And that privilege could be withdrawn if it is abused. So in any of these situations, the courts too will use their own powers. We do have powers where a matter is sub judice and somebody goes out in public on the television station, media, social media, to comment on those cases, because it does have a negative effect on the administration of justice, on how we handle our cases. Because when you then give a judgment, the way it is assessed is based on what has been in social media. But notwithstanding that, I would say that judges know the oath they have taken and will abide by that oath and not be influenced by social media. Thank you.
My Lord, you were very political in the last thing that recently, very senior members of the bar, we all know them. They are fond of being on politics today. They were commenting on cases that are before either the Court of Appeal or the Supreme Court. And this wasn't the case in the past. We are saying under your tenure,
yes,
will there be a procedure where you bring some of them to justice? Because they ought not to, because their comments and their analysis tend to influence the final outcome of those cases. And in most instances tend to bring about injustice. Because they are not aware, they are not sayers of the facts that are before their lordships.
yes.
But they will go out there, instead of arguing the cases in the court, they will go and sit down on television and be arguing the cases on television. And for the junior lawyers, the younger ones who are coming up, they are now beginning to think that that is the norm. If under your tenure, any of those senior lawyers, brought to book to say you cannot, when the case is in court, it has become, the matter is down sub judice. So if the court can invite, or even the NJC can discipline a senior lawyer who is fond of sitting down to analyze cases that are yet to be decided upon on television, in social media and all that, I think it will serve as a deterrent and will also help to bring back the integrity of the judiciary and the judicial system that we are talking about. That's why we are saying, under you, will you tolerate it? Because if you sound a clear note of warning to Nigerians, the teaming lawyers across the country will be wary that there is a new sheriff in town and that people should stop using the social media, using televisions to try to influence judgments in their favor, instead of going to argue the matters in the court. They play to the gallery, and you'll see them rolling from side to side on television and all that. Sometimes for some of us who have been in practice for decades, I shudder in fear, and nobody calls them to order. So we are saying under you, will you take steps to bring sanity to bear by collaborating with the bar and ensuring that those people are disciplined and that matters that are sub judice should not be discussed on television, should not be discussed on pages of newspapers, should not be taken to social media, should not be taken for analysis on radios by very senior lawyers. If they lose the rank of senior advocates of Nigeria because of those actions, it will serve as deterrent to those who are.
Thank you, Your Excellency.